And welcome back. We're officially entering the first segment of our show this morning, and as promised before the commercial break, we have been joined by attorneys Kareem Musa and Anthony Sylvestre, and the discussion this morning is the joint legal opinion that was released last week, and of course what that means to the legality, the constitutionality of the special agreement signed in 2008. Good morning, gentlemen. Good morning.
Good morning.
Morning, Molly. Good morning. It's all right.
Morning.
Let's begin by discussing firstly how this idea of having a legal opinion, based on perhaps an interpretation of what has taken place legally in respect of the compromise.
Well, if I may start off, morning again. As a parliamentarian, I can speak for myself when I say that I have always felt as though something as important as the compromise, which in fact is a treaty between Belize and Guatemala, was something that not only should have gone to the House of Representatives for it to review, ventilate, and approve, but it is also something, as Anthony led the charge in this joint legal opinion, found out that it had to be domesticated in our local law. We actually have to pass a law in Belize that recognizes that treaty that Belize signed in 2008. I believe Senator Amon Courtney raised that issue as early as 2008. And if you would recall, back then, the government had a supermajority in the House of Representatives. And so, if it wanted to, that would have been an ideal time for it to take it to the House of Representatives and have it passed. Because the main thrust of what we are saying in this legal opinion, and really there are two angles to look at. The main thrust is that this compromise, the way that it is worded, if you look at it, it says that we are giving authority to the ICJ to determine any and all legal claims, to determine the rights of the parties, if any, and to determine our boundaries. That third part is the most important part because, as you know, our Constitution contains a definition of the boundaries of our country at Section 1(2) and at Schedule 1 of that Constitution. And so what we are saying is that the Constitution is the supreme law of our country. On September 20th, 1981, the National Assembly of Belize enacted the Belize Constitution. And what that Belize Constitution says at Section 68 is that only the National Assembly has the authority to amend the Constitution. So what is it that we are doing with this compromise in 2008? We are basically assigning the power of the National Assembly to make laws and to amend the Constitution to the ICJ. Nowhere in our local law is that provided for. And so what we are saying in this legal opinion, and it is backed up by a multitude of cases, not just from Belize, being the BCB Holdings case, but we're talking UK cases because of the Brexit issue that has arisen over there. There are 2017, 2018 judgments that actually identify the importance of the separation of powers, being that you have the legislative, the executive, and the judiciary. Each of them have their own powers and should not be trampled upon. And what we are saying here is that in 2008, the executive, the ministers of government, being the foreign minister, basically came up with this compromise and is saying to us that we must now all go to the ICJ without going to the legislature and having it passed, because again, it affects the most critical, important document, instrument in our country, being the Constitution.
Let me just get an understanding as to some of the motives behind this, the legal opinion. This special agreement was signed in 2008, and in fact the wording for it was ongoing. The establishment of the wording for it was ongoing before that, at which part there was a bipartisan commission which included the People's United Party. There was a subsequent amendment agreed to in 2015. Yes. Why are we only seeing this legal opinion on the special agreement now? less than 2 months before Belizeans make the decision.
Yes, perhaps maybe I could jump in there. Speaking for myself, I want to become very much engaged, you know, in this the whole process. Sometime last year, when I attended my first ICJ seminar, and what I found and what I heard, it left me in a very uncomfortable position, and that led because.
What did you hear that made you uncomfortable?
Well, the presenters themselves, some of the information, at least appeared to me to be very much misinformation, and with respect to what I may have read before. And so that led, they started this process of actually having to start reading the cases and reading the special agreement, analyzing a similar approach as Kareem had mentioned with respect to Brexit, and that culminated in a legal opinion. But what should be pointed out as well is that as some has even argued at this stage, they're like, well, all of that is premature. So that because there is this contention that, well, everything is still in suspension, that nothing really matters until and unless there is a yes vote. However, as a matter of law and constitutional law, as Kareem pains to explain a while ago, that clearly is not quite the position. The position is that if we proceed as is anticipated, what will eventually happen is that the legislature's hand will be bound. It will be fettered, because then they will effectively, as the special agreement sets out, once there is a yes vote, the government has to, within a month,
the entire mechanism is triggered.
The entire mechanism is triggered. And that clearly then cannot, within that short time frame, seriously be argued that there's contemplation for the legislature after the fact to get engaged. Clearly, it has to be done before, because everything has to be done within that short month period. And so, to answer your question very shortly, it's a matter of whether, as some have argued, that, well, the agreement would have been in suspension for all those years. There was no clear indication that it would have been acted upon, and also, if you've had an opportunity to read the legal opinion, it requires some time and some effort to actually go through researching the matter, and so that is why we are here at this point in time.
Of course, but given your argument that a 1 month period after a yes vote, if there is a yes vote, was too short, I don't know if 2 months is any longer, and that's how much time you have allowed for this legal opinion to be ventilated and perhaps to take subsequent action.
Yeah. Well, the beauty about it, as we had discussed with the media earlier, is that the April 10th, 2019 is not a deadline. It is not as though we have to go to a referendum on that date. If you would recall, in 2015, and I think part of your question outlined that, Guatemala decided to postpone their referendum. 2013, they decided to postpone their referendum because they wanted Belize to change its law as it pertains to the 60% turnout threshold. And we did that. We bent over backwards to accommodate Guatemala. And so they postponed their referendum from 2013 to 2018. And so postponing the referendum is not off the table. We have to understand that. And so when you asked that question, it certainly brought back to mind the Honorable Philip Golson, our national hero, who said that the time to save our country is before you lose it. Now, I'm not saying that we're going to lose anything at the referendum, but certainly if it is last minute that Anthony, myself, and Dike come upon these cases from the UK that support this position that we have all felt, we have a fiduciary duty to bring that to the fore. And as Anthony rightly pointed out, let's be real, this compromise, I'm an elected member of parliament, and I have never seen a compromise until last year. It has been kept in the dark, it has been kept away from the public, and it is only now that we are in the final moments, January to April, that we see an actual effort being made by the government to put the compromise out there, and for us as the public to analyze it and digest it.
I have two questions to ask to follow up on what you're saying there. The first question being, it would seem as if though the train is in full motion at this point. It doesn't seem as if though the government would stop at any point to postpone or put off what is happening. That's the first point. The second point, my understanding was that there should be some legal challenge that ought to have come about out of this.
Yes.
And we're looking at a very finite timeline here as well. Where do we go?
Well, let me backtrack a little bit and backpedal a little bit. You see, the conclusion in a legal opinion is not that the process cannot or ought not to be done. It is that, listen, you cannot proceed to have this April 10th referendum unless legislative authority is given, unless the matter is taken to the National Assembly, and unless it is approved, legislatively approved. So that is something which can be done at this point in time without even a case being filed. You see, so that going back to your question earlier, Marlene, the onus really is on the government, because really what they are to have done, and even at this point, is to actually take the matter to the National Assembly and obtain that 2/3 majority, because that is what is the conclusion in the legal opinion, that the legislative authority needs to be obtained, that the matter needs to be taken to the House of Representatives, and 2/3 of the members in the House need to approve this process moving forward. And clearly, I mean, that can be done even as we're speaking right now. And so it is, even at this point, you know, perhaps maybe we are being too hopeful, but they can, if they really wish, they can do that. And so that if you think about it, if the point was taken last year, 5 years ago, the government could always throw behind and say, oh, but no, that we won't take it to the House. Yeah. I suppose recent comments make it and shown definitively that the government has no intention of doing that. And so because when you go to the court, one of the things, and it has happened to us before in a case that we brought, the court said, but how do you know that the legislature won't act? But at this point in time, at this critical point in time, I think it is clear, and a court, I suppose, would be able to be shown that it is clear that the government doesn't seem as though they will take that approach, that is to take it to the National Assembly.
Now, this is a part of what I think has led to a lot of confusion in all issues ICJ related, is because it is very legal in the language. Yes. A lot of understanding the complexities, and it's not that people can't understand it, it's just that we need the opportunity to break it down. Yes. And a part of what the premise of your legal opinion is going back to the special agreement, which is also called a compromise, that it equates to a treaty. Yes. That's the most fundamental point. Yes. The special agreement is necessary for Belize and Guatemala to go to the ICJ. In other words, they have to give permission jointly that they want the court to rule on this matter. So that is a part of what is, it's one of several ways that you can take a case to the ICJ, just to set the background. What you're saying now is that the special agreement equates to a treaty. And I want to ask what your what you're saying in your legal opinion, or your basis for that. Well,
firstly, the Vienna Convention on Law of Treaties defines a treaty as an international agreement between states. And that's in Article 1, and then Article 1(2) defines the process of ratification. Ratification is it's an act of the executive, it's an act of the government, where the government signs what we call instruments of ratification. And that is where the country, or a country, indicates on an international plane, listen, you know, we signed this agreement some time back, but we didn't make it know now that we intend to be bound by this. And as I was explaining to Kareem, I found a very an illustrative example by way of an extradition treaty that was entered into between Belize and Mexico. You had an extradition treaty that was signed in 1988. Curiously, it was signed by then Foreign Minister, our Prime Minister, Right Honorable Dean Barrow. And then it wasn't until 1989 there was ratification of it. And it wasn't until 2016 that treaty was actually incorporated into domestic law by way of a a act of a National Assembly. And so when we say that it is a treaty, it's because it is a treaty by virtue of the Vienna Convention and Law of Treaties. And what we are saying is that just as how the process, as I explained a while ago to you, you would sign, you would enter into the agreement firstly, and then becomes a treaty, a binding treaty when it is ratified. But then there's a next process, the legislative authority being given in domestic law locally, which hasn't happened with this special agreement, but what would have happened as I'm explaining in relation to the extradition treaty with Belize and Mexico. So that is where we are, and that is why we say that things cannot proceed, because you're seeking to give effect to this agreement, the special agreement, and it has not been incorporated. It is not, that legislative authority has not been given locally, domestically.
There has been a counterpoint that has been put forward by Attorney Lisa Schumann, former foreign minister and someone who's fairly versed in these matters as well. Now, how do you respond to the fact that she has put on record, look, by virtue of the fact that this thing is a treaty, it has everything in place to proceed, and it is considered constitutional and a legal instrument?
What I think we need to understand at this point is that what Ambassador Lisa Schumann was saying is that according to our Constitution, the Senate has the power to ratify this treaty, this compromise that was signed in 2008. And she is saying that that was done. What Anthony, myself, and Dickie are saying in this joint legal opinion is that the Senate does not have the authority to alter the Constitution. So there are two different things we're looking at here. Yes, the ordinary run-of-the-mill treaty that Belize has obligations internationally, that is fine. The Senate can approve those treaties, can ratify those treaties. But the moment you try to tamper with our Constitution, going back to what I was saying, being the supreme law of our land, the Senate does not have that authority. We have to understand that. Does not have the authority to then pass on the powers to the ICJ. How is it that the Senate all of a sudden has this power when Section 69 of the Constitution sets out the procedure that the House of Representatives and the Senate, which make up the National Assembly, only they can alter the Constitution? And so those are the two things that we have to look at. Yes, the Senate does have the power to ratify treaties, but not in this instance, because we are effectively altering, possibly altering our boundaries.
And you will know when the legislative authority is given, because you would have a law which says and has at it these words: being enacted by an advice and by the advice and consent of the House of Representatives and the Senate of Belize and by the authority of same. So that, as Kareem has indicated, both chambers need to give their legislative approval, and so that you can't have only the Senate doing this. You can't
have one without the other.
Yeah, and all the Senate did was the Senate authorized this executive act. They authorized the government to say, you know what, you could now go and you could on the international plane indicate to the countries that we intend to be bound by this treaty. But of course, it would have behooved the government before they did that to get the legislative authority, because they would have to come back at some point to ask the House of Representatives to, whether they agree to have this special agreement be acted on, and that hasn't been done even at this late stage.
Now, and again, I don't want to make the issue too complex. When you speak of the treaty, any other treaty, being able to be ratified through the Senate, that is completely legal. That is the process that can be done.
Yes.
Your issue boils down to what you keep on saying, that there is a possibility of a change in the Constitution. I want you to explain that more, because it really just goes back to the again, we're going to possibilities of what an outcome from the ICJ may be.
When you look at it, Marlene, it is actually more than a possibility. We are, if you look at the language, the wording of the compromise, we are giving the authority to the ICJ to determine our boundaries. We are saying our boundaries are already determined. It is set out in the Constitution. And so we are giving up the power. And so even if it is that the ICJ comes back and says we are going to move the western border 1 mile in because it was off, they are in effect determining our boundaries in contravention of our constitution, because they don't have the authority to do that. The only way that we can vest that authority in them is by taking it first to the National Assembly for approval and then domesticating it, as Anthony rightly pointed out, with all other treaties that affect the rights of Belizeans. You have to domesticate it. You have to have a local law to actually reflect what we have agreed on the international plane. Because let me tell you this, the international community does not care whether or not you had approved and domesticated the law. The fact of the matter is you have international obligations. And so if it is that we agree to go to the ICJ and that agreement says that their decision is final and binding, they concern not themselves whether you as a country, as a small country in Central America, have domesticated it in your law. The fact is it is binding and therefore it is going to affect us all. So we have to bear that in mind.
But is it a bit misleading to say that the ICJ would change the borders? Because the 1859 treaty is what is used to establish the boundaries or borders as we currently have them in the Constitution.
So then why give them the power to determine it?
And the 1859 treaty is essentially, Belize is seeking to validate that very same treaty at the ICJ.
Well, two things. We don't use the word change in our legal opinion because we don't know if it will change. But what is clear is that they will make a determination. So that in our constitution, presently we have that the 1859 treaty is used as a reference point as our borders with Belize and Guatemala. But hereafter, it will be the determination of the court. The 1859 treaty will be is a document that will be determined on, so that clearly that 1859 treaty will be no more once the court makes a determination.
It becomes void if that were the case?
Well, the court will make a determination as to whether the 1859 treaty has the boundaries properly defined as set out in our constitution. And once that is done, the force of our borders on the international plane won't be by virtue of the 1859 treaty. It'll be by virtue of the court determination.
I think let me put this out there. As the layman in all of this, with all the information that has been put out there, how do we not know that this only serves to confuse more than anything else? Because I'll be frank here. You have the Belize Peace Movement with its own position. They're trying to bolster an argument using a testimonial, so to speak, from a lawyer, a purported lawyer in Nigeria. And then you have the former technocrat who challenged the validity of the 1859 treaty based on the actual border, the frontier points and what have you. And then now there's the legal opinion being put forward. All of this notwithstanding the robust education campaign being undertaken by the referendum unit. I think perhaps to the average person, all of this is confounding. Well,
let me answer that simply by saying this, Isani. Certainly it is not the intention of myself, Anthony, or Dicky to confuse anybody. I think that the way that it is set out, it is very user-friendly, very reader-friendly, although it is very technical and it does cite many cases. But I think you just have to look at how the Prime Minister has responded to this joint legal opinion. If it were a ploy to confuse you, the Prime Minister would be the first person to come out and say, oh, this is just a ploy. But that is not what he has said. He has taken a careful look at it and he has said, you know what? I don't even trust local lawyers to review this legal opinion. I want a second opinion from a university professor from the UWI. That is how serious he is taking it, and rightly so, because you would hate to have a situation, Isani, for us to go through this entire process only to learn 2 years from now that in fact this ought to have gone through the National Assembly and we have made a major misstep. So the best time to correct that is now.
Now, and you interpreted the Prime Minister's words to say seeking opinion outside of Belize, but I wanted to ask that question in terms of the response that you have gotten so far. If you feel somehow that the substance of your legal opinion has been validated because it wasn't outrightly shut down by the Prime Minister in his first remarks so far.
Well, the purpose of the legal opinion was, as Kareem indicated, so as to allow for further consumption by the general public as we proceed through this process. I will not say, or it's difficult to answer that question whether we feel it's been validated or not. Suffice to say that, as Kareem indicated, if it was without substance, it would have been shut down out of straight away. You know.
Now, I hear what you're saying in terms of putting it out for the general public, but really, this is not. Let me say it this way. Yes, it is important for the general public to understand, but fundamentally, this legal opinion is not really for Jane and Joe public. This is really for the legislators to look at and somehow sound a bell or decide to take action or go the other route of a legal opinion. You are really seeking members of government to be able to say, whether by conscience or because they feel that there's potential in this opinion for a legal case.
And it is to add to the overall discourse, Marlene, because it is not just an issue that I have felt strongly about, Senator Courtney has felt strongly about, but even members of the Belize Peace Movement, I believe they were discussing the matter with Mr. Dickie Bradley, and they brought up this as one of their issues as well. And so it's not just for attorneys, it's not just for the legislature to look at and say we need to make a move on this. It is to add to the discourse moving forward. And let me say this, ordinarily, a case would be prepared first, a legal challenge would be prepared first, filed in the court of law, and legal submissions would come about 6 months to a year later. But what Anthony has done, along with myself and Dickie Bradley, we are only backup singers here, but what we have effectively done is put out the entire legal submissions. Never has that been done before, that you see the legal arguments coming forward before the case. And so that is important for us to realize that we have done all of the legwork before even taking the matter to court, and to afford the government that opportunity to rectify the problem before we move forward.
And I think that that's a valid point that we can pick up, but we have to take a very quick break, and when we come back, we'll continue this conversation. So please stay tuned.
When someone you love becomes a memory, the memory becomes a treasure. Channel 5 introduces the Daily Obituaries. The Daily Obituaries will broadcast all death and funeral announcements and memorials to honor your loved one's life and memories. The Daily Obituaries airs on Channel 5 prior to the evening newscast, with subsequent repeats at 10 p.m. and 12 noon the following day. It will also be placed online on our social media platforms, all for a standard package fee. Celebrate their lives and memories with Channel 5's Daily Obituaries. Honor in life and reverence in death.
We're back, and if you're just tuning in to the show for this morning, we are continuing our conversation with attorneys Kareem Musa and Anthony Sylvestre. Last week, they presented a legal opinion on the special agreement between Belize and Guatemala. And before we went to the break, you were talking about the fact that you have put out your legal opinion before taking any type of court action. Yes. But that's an interesting point, because I think people want to understand, why say you have the facts to say that the special agreement is in any way invalid and not take it through a legal challenge?
Well, I think it goes back, Marlene, to what we were discussing earlier on in an earlier segment, that remember, everything is hinged on the legislature, and the legislature can, a meeting of the House of Representatives can be convened as special session at any point in time, so that it is really, as you have articulated, it's been urged on the government, listen, look, You know, we're not saying that this process ought not to go through, but if anything, we've learned over the last 11 years that things must be done legally and properly. And so that is what is being urged on the government to do at this stage, to obtain the legislative authority, take it to the House and get the 2/3 majority in the House, members in the House supporting the process.
Now, for any person who's watching this, we know what happens in House meetings. And they may be saying, listen, you're talking about including an additional step that would have just been a rubber stamp anyway, had it gone to the House.
Well, I'm not quite sure if it's a rubber stamp. I mean, as things are now, 2/3 majority would require bipartisan support. And I think an issue as fundamental as this should obtain bipartisan support. And so, you know, there was a case which says that the wishes of the people are expressed through their elected representatives. And so that clearly a process like this should have that be done. And it's not only a gut feeling, it's also what is constitutionally required.
Yeah. But that is being theoretical, because at the end of the day, we say, okay, we need bipartisan support, we need the buy-in from the opposition to move this thing forward. But most of us believe as if though, you know, sometimes we oppose for the simple sake of opposing. So how do you really put that forward and expect that others would support it from the other side?
Well, this, as you know, Isane, is an issue of national importance. And I don't think any elected representative in the House can shirk that responsibility. You owe it to your people to do what is right by all of Belize in a situation like this. And going back to your question, Marlene, it cannot be that this is just a rubber stamp, because as Anthony pointed out, it requires a 2/3 majority. And so when you bring this compromise to the House the way it ought to have been brought from since 2008, it affords representatives, including myself and others in the opposition, the opportunity to make contributions, to analyze the wording that our foreign minister and a few others agreed on to take our country to the ICJ. Going back to the wording of this compromise, it says to take any and all legal claims. I have heard many people, including Ms. Sandra Coy, whose opinion I respect greatly, she has said that she does not like the way that this compromise is worded. We don't like the fact that it says the ICJ has the power to determine our boundaries. We feel confident that our boundaries were determined by that very 1859 treaty. And so perhaps that wording should not be in there. Yes, we may look at the legal claims of Guatemala, but why do we have to allow them that opportunity to determine our boundaries, which we know has already been determined? So there are many ways to look at this, but what we're saying is, had it gone to the House, it would not have been just a rubber stamp. We owe it to our people to fully ventilate that compromise and to put the wording as best as it can possibly be before we go to the ICJ.
Now, your legal opinion is hinged on quite a few things, and I wanted to talk about that further, because any change to the Constitution, which is your fundamental point, is if something is going to make a change in the Constitution, it needs a 2/3 majority in the House, right? That has not been done yet. The special agreement does not change the Constitution.
No,
the people have not voted yes in a referendum to take the case to the ICJ, and the ICJ has not ruled that there would be any shift from the 1859 treaty. So there are all these steps that may or may not take place. That really is the foundation of your legal opinion. How do you explain that to me?
Well, let me see if it could be explained. The special agreement, one reads Article 1 and 2, and it tells you clearly what is the intention, what is the intent of the government to have this matter be submitted to the ICJ. And the point is a very simple point, that only the National Assembly can do that. Only the National Assembly can say, listen, you know what? We are the constitutional lawmaking body which has determined in the past the boundaries of Belize. But you know what? We want this claim to be resolved, and so we will, albeit temporarily, transfer this authority to the ICJ, because remember the decision of the ICJ is binding, so that they won't have a choice again. Their hands will be bound. It's fettered, and the National Assembly can't be fettered. So only it can say, you know what will happen? We just want to transfer this authority, and so when the ICJ makes a decision, whatever that decision is, we will just comply, and then we will just make the necessary changes, whatever that may be. And so that is where this separation of powers doctrine comes into play. Because what has happened is that it is the executive, the government, which has done that. And that is why we say this needs to obtain the legislative authority. Yeah. We're not saying that it can't be done, you know. As you can see, this is something that can be done next week. If it is taken, well, we don't know what will be the result, but at least take it to the House. That is a necessary process that has to be obtained before the April 10th referendum.
And I think going back to your question, Marlene, and one of the cases, I'm not sure if it's the UK withdrawal or the Miller case, the judge in that case described it quite appropriately when she said that to wait so long, it would be after the trigger has been pulled and the bullet has come out of the gun. Because if we are to wait until after the people vote yes, then our hands are tied as a legislature. If we are to wait until the ICJ comes down with its binding decision, our hands are tied as a legislature. And so to wait until those two things have occurred, it is too late, because our discretion has been fettered at that point. We have no choice but to go along with either what the people have said or what the ICJ have said. And we are saying that that is too late. We must do that beforehand.
Anthony, you said that the special agreement transfers the power to the International Court of Justice.
That is the clear intention of the agreement.
But we've missed a very important step. And that very important step is the referendum. Well, because, let me finish my point. You spoke of elected officials being representatives of the people. Our hope and our intent, and theoretically what is set out in their rules, is that they go to the House and they vote according to what the man on the street who voted for them wants them to do. That's essentially what should take place. Could it not be considered that this is the very same action when you give the actual voting public the opportunity to decide whether or not you want this special agreement to be fulfilled? That is
true democracy. That is so. That is the wishes of the people. Certainly are expressed through the ballot. But here's the thing, and I'm glad you brought that up. Under our laws, the results of a referendum are not binding. The government can say, well, I don't know if I want to comply with that. But when you read the special agreement, it calls for a legally binding referendum. And
again, there has been a counterpoint being raised, though.
And that's the thing, and that is why we also set out in the opinion that what is needed is this special legislation to let that have effect. Because a referendum is akin to an election. It's a very, very expensive process. And so that our referendum act, it is not legally binding, the result is not legally binding, so that the legislature, the government, no entity really has to act on it.
But that notion has been struck down already in a counterpoint that was also raised by Lisa Schumann, who said, and she referenced the case of Veos before the Privy Council,
which I also was involved along with her, working with her from the get-go. So we are very much aware of the Veos case and what that says. Fortunately for us, judicial precedent, one doesn't need to actually be in the case to be able to rely on it. One just needs to read the case, and if you read the case, it tells you that our referendum scheme in Belize is non-binding. And the point is this, is that when you read the special agreement, it calls for a binding referendum, because that decision is supposed to bind the government and supposed to bind the National Assembly. And so that can only be done by the National Assembly passing a law to give that effect, to say, you know what? We'll have this referendum on April 10, and this referendum will bind the country of Belize, and it will bind the National Assembly, and that is very, very important. Otherwise, you have a referendum which has no legal binding effect in a country. Surely, it cannot be in a position that we spend millions and millions of dollars and have that state of play.
Going back to the original point, and we cannot miss it at all. The Constitution does not say that the people in a referendum can change the Constitution. It does not say that. We have to go with what the Constitution says. It says the National Assembly and the Senate, which includes the House and the Senate, those are the two entities that can change the Constitution. No other way. And so we fully appreciate the point that Marlene is making, which in the referendum will allow people to voice their opinions on the compromise, whether they accept it, whether they want to move forward to the ICJ or not. But at the end of the day, what Anthony, myself, and Dickie are saying is that we have to be compliant with what the law says. And so far, we have missed that major step.
In your legal opinion?
No,
and
no,
and because the Prime Minister has clearly said they will be seeking their own legal opinion on this issue as well. So quite likely what may happen is that we have two different opinions as, well, one possibility, I won't say likely. We have two different opinions as to what the special agreement and the legality of the special agreement really is. I want to bring this back into today's context. There are many Belizeans who've made up their minds as to what they want to do in the referendum. But there are many more who are undecided. And this is just from quick polls and talking to people. Some say, I don't know what to do. I think maybe yes, I think maybe no. And how do you present this information without making it more confusing to the person who has to make this decision?
We come on your show.
And
we try to explain it as best as we could.
As yet, because I mean, you're saying that, okay, you are making a decision based on an agreement that we are saying is invalid, which may even stop people from going out to vote. They might say, oh, well, you know, the Dickie and Kareem and Anthony said that special agreement isn't even legal, so why even bother?
No, the object again is to because remember the people can also force their representative to do what is legally and constitutionally required, and so that again is what is the purpose of the legal opinion, for the right thing, for the legal and constitutionally proper thing to be done. I don't want to have it further be complicated, but as you may know, there's also in the legal opinion the argument that it's the document, the special agreement itself, that should have been placed in the referendum, because the special agreement contains a mechanism as to what is to be done to arrive at this settlement, this resolution of this Belize-Guatemala dispute. In our referendum act, it says any proposed settlement is supposed to be put to the people, and so the argument is that it's the agreement itself that ought to have been put to the people, because in the agreement there are different mechanisms which people have issue with. For instance, in Article 2, it says that the court is to make 3 determinations. But some people may have been okay with going to the court, but they don't want the boundary issue to be determined by the court. So those are things which really should have been put to the people before. But now we've been boxed and been asked one specific question. There's also the issue with respect to Article 8, which says that, for instance, after the referendum, you only have a month within which you have to submit these matters to the ICJ. Those are things which properly the general public should have been asked. You know what? Are you comfortable with this?
Because are you implying that there should be a referendum before a referendum?
That is exactly what we are saying in our legal opinion. That the referendum should have been placed as though whether the government of Belize ought to have entered into that special agreement, because that special agreement, as it is at this point in time, is binding. So the question should have been put to the Belizean public: do you want the government of Belize to enter into this agreement that has these various mechanisms that are to be employed? It's not solely the question of whether we want to go to the ICJ. It's the entire agreement that should have been put to the Belizean public. And again, I don't wish to complicate the matter, but it was a matter of law. That is actually what ought to have been done as well.
You know, gentlemen, this is such a historic issue, and there's been so much that has happened over the years, and sometimes we get fixated on today versus what has taken place in the past. You are right when you say that this issue, the settlement of the Belize-Guatemala issue, had to go to the people no matter what process was undertaken. And in fact, when the facilitation process took place, there was no legal objection as to whether or not the negotiation should have proceeded. And there would have been a referendum, but Guatemala rejected it. So if it was okay then, why isn't it okay now?
No, Marlene, there has never been, it's the first time the country has actually entered into a binding agreement as the special agreement, which, as the agreement sets out, requests the court to make a determination on a boundary between Belize and Guatemala. That was never done before, and so that is so I suppose there is no previous precedent in terms of why persons ought to or ought not to have made a legal challenge before, but this is the first time that this has been done. As when you read the special agreement, you will see that the process has been a very long process. And and speaking for myself, I have to commend all the efforts that have been undertaken by the various ministers of foreign affairs and ambassadors and all our public officers who have been involved in this process, because it's a process that is the resolution of this dispute, which, speaking for myself, needs and must be resolved. But the thing, but our point is this: but it must be done constitutionally. That is a very simple point.
So what happened? Less than a month, April 10th, the polls open.
Well,
and you have this legal opinion saying that the special agreement is invalid because it wasn't taken to the House.
Yeah, well, I believe Anthony said it right earlier when he said that we must first give the legislature the opportunity to make right what we identify as being wrong. If that does not occur, and I think the time is running out, as you have pointed out, I think Anthony, myself, and Dicky will have to take the matter to court. There are several different claimants. There's no shortage of claimants. We have individuals who own land that have contacted us and said, listen, I have rights that I could possibly lose if the ICJ were to determine our boundaries and it affects me as a landowner. We have parliamentarians. I am part of the legal team, so I won't be a claimant. I think I had to make that decision. I have to choose if I'll be part of the legal team or become a claimant. And so we need to look at this matter and take it to court.
And what would be your first action? Filing an injunction against having the referendum?
That would be one of the remedies that we would be seeking, yes. In addition to declarations that, in fact, the special agreement is null and void for not having gone through the constitutional process as required by law.
Filing an injunction, however, as one of the remedies, as you've pointed out, would you have the strength of a legal argument to persuade the court, look, in spite of everything that has been put into the campaign so far and the fact that we're right at the precipice of the actual referendum, that everything should be stopped, and so we pay sole focus on getting this legal aspect right? Do you believe that you would have such a cogent argument?
Well, the thing about it is that a court, an injunction, as you know, is where someone files a claim, and there is substance in the claim, and the court has to make a determination and say, listen, if we don't stop the process, then this claim will be of no effect, because
it's like a pause button. Press
so
pause.
Let's put a pause, and so that is effectively, so if we are able to obtain an injunction, and clearly that would indicate that there is merit to the claim. I know this process has been and continues to be a very topsy-turvy process for us, and interestingly, in England, in the UK, where they are experiencing this Brexit phenomenon, similarly, and in our research, when we were looking at the Miller case, similarly, the general public, similarly was had this feeling as well, and it. Fortunately or unfortunately, the way our constitutional system is set up, we have an executive, we have a legislature, and we have a judiciary. They have their own powers, and they have their own duty and obligation. And what we have here, unfortunately, is a conflict, a clash of the executive doing one thing and bypassing the legislature, who has their own authority and power, and that is, which hasn't been engaged. And with a legal claim, we'll have the court engage as well, no? Yeah.
No, I'm trying to phrase the question properly because I know you've taken a position, Kareem specifically, publicly, on no to the referendum. And my question is, if there's an injunction, if this goes to the National Assembly and there's a decision to change the wording, hypothetically, since a lot of this is just what ifs, that special agreement has to be amended along with Guatemala. They have to be in agreement to then sign on to it once again. That's another process of negotiation and fighting over placement of words and whatnot. The question is, and one of the fundamental points being brought forward, is that this dispute has been ongoing for a very long time, and we need at some point to find a resolution. We have been trying many years in trying to find a resolution. And I want to ask you directly, do you want to see a resolution to this issue?
Absolutely, Marlene.
Okay,
I will say this.
What is your preferred mechanism?
No, I will say this. The way I look at this entire process, it's on a continuum. It's on a spectrum, so to speak. There are those who feel very strongly no to the ICJ, not now, not ever. I do not put myself in that category. Moving along that spectrum, going towards a yes to the ICJ, there's a middle ground as well. That middle ground is no, we are not ready to go to the ICJ. And you might ask yourself, if not now, when? Well, let me tell you this. I have witnessed for the last 10 years a government who has claimed that we have airtight cases, ironclad cases, fall down 95 to 99% of the time in court. And so what I am saying is that we must get it right. If I identify something as not having been put in place, like the Sarstoon Protocol, that is essential, Isani, because if you look at Article 7 of the 1859 treaty, a lot of people only limit the discussion to the cart road. But not a lot of people are aware that it says a cart road or access by the river. What does that mean? It means that England had agreed with Guatemala to provide access by the river if they did not put in the cart road. Is that what Guatemala is doing by taking over our Sarstoon? And what have we been doing as Belize to make sure that we don't set that right? That is not your boundary. That is not your territory, Guatemala. And so that is why I'm saying, before we go to the ICJ, it is absolutely important that we have a Sarstoon Protocol in place. Similarly, I am saying that we must get it right in terms of our constitution before we go to the ICJ. And so I want to make it very clear. I am not averse to going to the ICJ. I just don't see Belize being ready. And given our track record in the courts, I think we must get this issue right.
I definitely, like any true Belizean, would want to see this issue to be resolved. I'm in the middle ground at this point in time because, as I see it, the constitutional, the process hasn't been validated by the legislature, and so if that is done, my position in respect to the question of whether we should go to the ICJ or not, I would be open to make that determination. But as things stand, we haven't reached that point.
So you're saying you're undecided?
No, I'm not saying that I'm undecided. I'm saying that at this point in time, based on the way our constitutional framework is set up, we haven't reached that point for a determination of yes or no. You see, so that is why I say I'm at a middle ground. Yeah, but there are. Let me say this.
If there's an injunction, if you file for an injunction, you don't get it. April 10th, the referendum comes. You'll go to the polls. Will you participate?
I will participate. I will have to vote no because it's not based on a gut feeling, on a solid legal basis that the process at this point in time is flawed. And we're saying that all of that could be cured, and all of that could be cured, and we'd want for it to be cured. We'd wish for it to be cured. But only the legislature, only the government at this point in time, they could convene a special sitting to have that be debated and for that to be voted on.
Okay. All right. And have you set out a timeline, lastly?
For the case?
For when you would file for a case if there is no action taken?
We'd want to think that a case should be filed by this week.
Okay. All right. Well, thank you for coming in and explaining the legal opinion that you've put forward.
Thank you very much
Thank
for
you,
having
Marlene.
us.
Thank you, Ms. Sane.
We're going to go ahead and take a break, and when we come back, we'll be joined by representatives of the Friends for Conservation and Development and a bi-national youth action plan that they are undertaking. So stay tuned.